Hi everyone, and welcome to today's webinar, which is part of our Digital Economy Live series, where we go behind the headlines to explore regulatory and legal developments shaping the digital economy. I'd like to begin today's session by acknowledging the Gadigal people of the Eora Nation, the traditional custodians of the land on which we're recording this webinar, and their connections to land, waters and community. I pay my respects to elders past and present and extend that respect to all Aboriginal and Torres Strait Islander peoples present. My name's Kirsten Webb and I'm a partner in the competition and regulatory team here at Clayton Utz. It's my great pleasure to be facilitating today's discussion with Sarah Court, Deputy Chair at ASIC. Sarah's well known for her leadership in regulatory enforcement and has been instrumental in ASIC's approach to tackling digital and financial sector risks. Prior to her appointment as ASIC Deputy Chair, Sarah was a Commissioner at the ACCC for 3 terms. And I can say from my personal experience that Sarah's great to deal with. You always know where the issues are and where you stand. Today we're going to be exploring how ASIC is engaging with digital risks, including cyber resilience, scams, digital asset regulation and AI governance. So let's get started. Sarah, welcome.
Thank you for having me.
We might get started with ASIC's role and working with other regulators. In our last session in this series, we spoke with Kate Reeder from the ACCC, and she took us through the work of the ACCC and the Digital Platform Regulators Forum, which is the ACCC, the ACMA, the eSafety Commissioner and the OAIC, but not ASIC.
No.
Though ASIC's very involved in the digital economy, of course. So perhaps could you take us through how ASIC works together with other regulators and what's your focus?
Yeah, no, absolutely. And I used to work closely with Kate, so fantastic she was here. And I also used to get involved when I was at the ACCC in a lot of the digital platforms work and some of the enforcement matters as well. So yeah, we don't sit on the, what did you call it? The digital platform, DP Reg. No, we don't sit on DP Reg. But we do, as you say, have a real interest in all things digital and data. In terms of working with other regulators, we certainly work closely with the ACCC, which will come as no surprise. And of course, ASIC shares the administration in particular of the Australian consumer law. So we have provisions in the ASIC Act that mirror the ACL, and ASIC's jurisdiction is all things financial services. So when I'm describing that to people, I say it's banking, credit, superannuation and insurers. So everything that sort of comes within that ASIC is dealing with. So we deal a lot with the ACCC. We deal a lot with the OAIC, which I'm sorry, there's so many acronyms here, but that is the Office of the Australian Information Commissioner. And one of the reasons that we have a close relationship with the OAIC is that they, of course, are the regulator responsible for data breaches. And so, in effect, if you think about the kinds of issues that the OAIC are looking at, and just to pull a few random examples, the Medibank, Optus, Latitude, to name but a few, the Information Commissioner is looking at those things and working out if there's action that she should take. And what we are interested in those situations is whether or not investigations reveal any failures by directors. Are there governance-related issues? Are there senior executives or officers of the company that are somehow implicated in that? So we work really closely with the OAIC. The ACMA sits on that group as well, and one of the areas, Kirsten, where the ACCC and ASIC and the ACMA work very closely together is in, sorry, this is yet another acronym, the NASC, which is the National Anti-Scam Centre. And that's a relatively new institution. It was set up under the current government, and it is it's effectively a scam, an economy-wide scam fighting entity that brings together regulators, government, and very importantly industry, to all come together to fight scams. So I sit on a regulator steering group with colleagues from the ACMA and the ACCC in relation to the NASC. And I think though, if I could just sort of pivot a little bit, the other area where we have very close relationships with a regulator is with APRA. So I'm sure everyone watching this webinar will know, but in terms of financial sector regulation in Australia, we have a Twin Peaks model. We have APRA that deals with the prudential side, and we have ASIC that deals with conduct. And one of the things that came out of the Hayne Royal Commission some 5 or so years ago now was Commissioner Hayne saying that ASIC and APRA need to work a lot more closely together, in his view. And both regulators have really taken that to heart. And we have engagement with APRA on pretty much a daily basis at all levels. So right from the commissioners and APRA members right down to our operational teams. APRA has a real interest in cyber and cyber resilience as well. In fact, there's a data governance standard that APRA administers called Prudential Standard CPS 234, which doesn't sound particularly interesting, but hopefully no one from APRA is watching as when I say that. But in effect, it is a really significant standard for APRA licensed entities because it sets out the role and obligations of the board in relation to information security, and it really has at its heart that the board is ultimately responsible for information security. So look, I could keep going because there's actually a whole number of other regulators we work with regularly, the AFP in relation to executing warrants, the ATO in relation to Phoenix activity, lots and lots of international engagement, but maybe I'll leave it there.
Yeah, no, thank you. I was going to ask whether there were any others because it seems that your remit overlaps with many others, I suppose. And even the subject matter of this webinar and this series, the digital economy, what even is that? It's sort of everybody's business, in a sense, is now participating in the digital economy.
And as we were saying just before we came on to the webinar, I mean, when people are talking about, all things digital, I mean, really everything we do now has a digital component, doesn't it? So we're really, I think, from an ASIC perspective, I think when we're talking about digital issues, particularly from a compliance and enforcement lens, we're really thinking about cybersecurity predominantly and the risks that come from or flow from companies and entities, both that we regulate and in the broader economy as well, becoming the victims of a cyber hack, and then in particular what potential impact that can have either on A, market integrity, and B, consumers, investors.
Which brings us very nicely to my second question, which was exactly on the topic of cyber resilience and technology risks, both of which we would say are top of mind for our clients, for boards, for senior managers, for general counsel, of course, and probably for consumers as well, from the consumer perspective. I wonder whether you could take us through, perhaps first, what ASIC's expectations are of organisations, and then secondly, perhaps outline some of the actions ASIC is taking in relation to this strategic priority area.
Yeah, so we've long taken an interest in the cyber resilience of Australian companies, and that's very much reflected in our strategic priorities, what we put in our corporate plan, what we report against every year, but also in our enforcement priorities that we announce at the end of every year. So we announce enforcement priorities in November at our annual forum that take effect into the following calendar year. So for 2025, two of the enforcement priorities that we're interested in that are relevant to this topic are firstly the failures by licensees to have adequate cybersecurity protections. And just pausing there, just to remember too, Kirsten, that so ASIC licenses a whole lot of entities in the financial sector. So we license the banks and the insurers, the superannuation trustees. They have what we call it an AFSL, an Australian Financial Services Licence. And if you have the privilege of holding an AFSL, then you have additional obligations imposed on you that go well beyond the normal protections of the consumer law. So it's a different, one of the things I've come to learn about and appreciate more since I've come to ASIC, that is different from that sort of whole of economy regulation and enforcement that I used to do at the ACCC. So failures by licensees to adequately have cybersecurity protections is the first thing we're really interested in. And then the second thing is really, bread and butter work for ASIC, which is governance and directors' duties failures in relation to cybersecurity. This statistic is probably well known to lots of the people viewing the webinar, but we do recognise cybercrime is prevalent, right? So in 2024, I think the statistic is that there is a new report of a cybercrime to authorities in Australia every 6 minutes. And I think when we at ASIC are talking about cyber resilience, cyber security, I think we've come to recognise that for many companies it's not going to be a matter of if this happens, but more like when it happens. And I think then if it does happen, there's two elements that we are interested in. So one is I'm talking predominantly about governance, directors' duties and the like. But the first question is, well, what cyber security protections did your firm, entity, company have in place in the first place? And I think the level of protection required, we recognise that will vary depending on the size of the entity. So we wouldn't expect, the Commonwealth Bank or Medibank Private, for example, to have the same levels of security than we would from a suburban hairdresser or butcher, for example. Although I also wouldn't want to dismiss the importance for small businesses as well, because as we're feeding more and more of our data and information to do even basic transactions, it does become increasingly important that there are cybersecurity protections in place across the board. So the first issue we're looking at is, the size. The second issue that's relevant, of course, is what is the nature of the risk? So if you're an entity that is collecting very personal, sensitive material about your customers or clients, let's say, sensitive medical information, for example, or potentially financial information that, if hacked, can be used to access accounts or to commit fraud on your clients, customers and the like, well then it seems self-evident that there's a pretty significant onus on you as a company to make sure that you've done everything reasonably possible and practicable to make sure that you've got appropriate protections in place. So that's at the upfront on the one side. And then the other issue that we're really interested in is recognising, as I said a moment ago, that these events do happen with all the efforts in the world, and where we have seen what we consider to be sort of unacceptable failures is, how do you respond to that? How do you deal with your customers, your clients? How quickly do you make them aware that their information may have been compromised? What tools do you give them? Do you direct them to the OASC? So there's the prevention and then there's the response. And from our perspective, both of them are significant. And that whole area of cyber risk management, in our view, really demands board level attention. So from the top down, that's our view. Yeah.
And at the board level, and this is a gross generalisation, but you maybe have people of kind of our vintage or there or thereabouts who are sitting on boards who may not have deep understanding of the IT systems or even the questions to ask in order to inform themselves about the state of the relevant entities' cyber protections. Is that something that you have any sympathy for?
Well, it's something I certainly understand. But I think the chair of ASIC, Joe Longo, who's got a very long history in corporate governance and directors' duties issues. In fact, he's been at the AICD Corporate Governance Summit just this morning talking about, this very issue, what is required, what skills and expertise is required of directors. And I think our view is that, directors have to be curious. I mean, you're put on a board for a reason, right? And one of the reasons is to identify risks, to deal with compliance. And I know a constant complaint of directors, and I very much understand this, is just, that the regulatory burden is getting higher and higher, and are the regulators unreasonably expecting too much of directors? I think the flip side is, if you're a publicly listed company and you're a client or a customer of that company or a shareholder of that company, then you expect your board of directors to be doing all things reasonably necessary to protect the company, to look after the information and the like of your customers. So our response would be, you need to do enough. You need to be able to satisfy yourself that everything that is reasonable is being done. Now, there's a variety of ways that you might do that. You might develop that expertise or experience yourself. You might, bring in particular board members that are tasked with effectively being the translator between the business and the risks and the rest of the board. You might commission independent reports who can give you those kind of assurances. I think our message is, though, you can't turn a blind eye to it. You can't say, oh, well, I don't really know anything about technology, so I'm not going to worry about those risks. Our view is certainly that is insufficient.
Yeah, that makes perfect sense. Has ASIC taken any enforcement action in this area?
Yeah, we have. There's one case that was determined back in 2022. It's called RI Advice, and that case related to the holder of an Australian Financial Services licence, and the court held that it had failed in its licensee duties by failing to have adequate risk management systems in place to manage cybersecurity risks. And in that case, there had been a number of significant cyber-related incidents at authorised representatives of RI Advice over a quite lengthy period. And in one of those instances, what's described in the case as an unknown malicious agent had obtained through an attack effectively access to a whole range of personal information, confidential and personal information of several thousand clients. And ASIC's case was that RI Advice as a licensee held these general licensee obligations, and that by failing to by failing to have the appropriate systems in protections in place, that it had failed in its in those duties, and the court found that was the case and imposed a fine. But what I can say, Kirsten, is that we have a number of other, that was a couple of years ago now, but we do have a number of other matters where we are very closely looking at these kind of issues, and I suspect you'll see more action relatively soon.
Yeah. That makes sense. So it sounds like, before we move to our next topic, kind of key messages for our audience then. There's key messages for board members that you've been through, but also for the entities themselves, particularly if they're a licensee. Yeah,
I think those the key messages, as I said before, really are that these issues are prevalent, and it's worth, isn't it, just keeping in mind, why do we care about this? Well, we care about this because if your company is holding this kind of personal information and it is hacked and that information is, released to the dark web or wherever else it goes, it can then be used for malicious purposes against you. So there are very real people impacted by these kind of breaches. And of course, I think we're going to talk about scams later, but one of the things we're doing at ASIC, we do a lot of work in scams, and I did a lot of work in scams when I was at the ACCC as well. And the scam-related misconduct and impact, of course, is just exponentially rising despite enormous efforts by regulators, governments, industry across the board. And so that's where we see the results of some of these data hacks, is then, we see very, very real victims at the end of it, which is why it matters so much.
Yeah, fair enough. And then perhaps last comment, I suppose, before we move to our next topic, but circling back to our first topic, for the data hack type of situations you've just mentioned, that would be a good example of where you take your own action, of course, but presumably you work with the OAIC and
Indeed.
the AFP or whatever other relevant regulators.
Absolutely. And we have to be really conscious, because these things do spread over a whole range of different regulators, at the ACCC as well. We have to make sure that we are, taking coordinated action, and often we'll talk in those terms to say, which is the best agency to investigate something and ultimately take something on.
And is this an area where you may also work with international regulators?
Oh, indeed. Well, certainly in relation to scams, because most scams are not initiated from Australia, which is one of the reasons that scam-related enforcement is really extraordinarily difficult.
Yes.
And why it's really hard once money is gone, has been scammed, very hard to get that money back because it just gets transferred. Usually it's converted into crypto and then it disappears offshore. So we frequently work with international agencies, particularly ones who have discovered scam-related or cyber-related crime that is coming from their jurisdiction, something they're investigating, and they're finding Australian consumers or investors that are being impacted. So yeah, it's critical.
Okay. We might move to our second topic area, which is scams. Scams, fraud and digital consumer protection. And obviously from ASIC's priorities and from the discussion that we've just had, Sarah, ASIC's prioritising investment scams and fraudulent financial products. Could you take us through what ASIC's doing both proactively and in enforcement action?
Yeah, so as I said when we started talking, Kirsten, so we're doing a lot in relation to scams with the National Anti-Scam Centre. And I think one of the things consumers have been a little frustrated about over the years is if they've been scammed, and even the word, and you may have heard me say this before, but I'll just repeat it, even the word scam I think is slightly frustrating in terms of what we're actually talking about here. Scams used to be, people walking around with a bucket pretending they're a charity and
Yes.
getting money, and you pop your money in and you realise you've been conned or scammed. These days scams are effectively global organised crime. So a better word for it might be, cyber crime, economic crime. That it really is on a industrial scale, and the methods by which people are able to persuade you to hand over your money are just ever increasing in sophistication. Again, when I started working on this, when I was at the ACCC 15 years ago, we used to have pamphlets and things where you could tell people how do you pick a scam. You'd look at things like, the address doesn't make sense, or there's poor grammar in the offer, or, words to that effect. These days you can look at, if you're looking at something like an imposter scam, which is where you've got a scammer who is replicating a genuine investment opportunity and you put them side by side, there is just no way you can tell the difference. And with the rise of AI and deepfake technologies and the like, it is extraordinarily difficult. So come back to what I was saying to start with. So consumers are saying, well, who do we report things to? There's so many different agencies involved in scams. And so that's why the National Anti-Scam Centre was really set up, so that the ACCC for the government is now the lead agency in respect of scams across government, but a whole lot of other regulators work with the ACCC. And our jurisdiction at ASIC is in relation to investment scams. And unfortunately, investment scams, I think the statistics are still today where consumers lose the most money because they just, they think that they're going to be able to make a whole lot of money quite quickly, and then that money is just taken from them. So in relation to the work that we're doing, I've talked about the work we do with the NASC. We also have at ASIC what we call a takedown service. So this is specifically in relation to investment scams. But because enforcement in relation to scams is so difficult, all regulators are involved in the area are really doing everything we can to disrupt scams at the source. So before people can get sucked in by them, if that's the right phrase to use. So we have entered a partnership with a global provider, and that enables us, as soon as we have reported to us, and we're very reliant on members of the public to tell us when they've spotted an investment scam, we have a look at it, a look at the URL, a look at what's offered, and if we're of the view that it is a scam or likely to be a scam, we send it off to our provider, who then works behind the scenes with the domain host to get that taken down. And we do that all day, every day. So we've taken down more than 10,000 of those sites. And the other thing that we're able to do through that service is that we monitor to see if the scam pops up again, instantly. And so we are seeing some real positive results in that way. So that's terrific. Another thing that we're doing in addition to that and related is we have an investor alert list on our Money Smart website. And again, for anyone watching, the Money Smart website has got so much information about cyber and scams and how to protect yourself. It's really worth a look. But we put onto that investor alert list if we become aware of an investment opportunity that we think is fraudulent or false, we put it on that website, and we've had feedback from people that have been, just about to invest quite significant sums of money that have gone on and done a search and found that the entity they were about to invest with is on that site. So that's another really effective tool. Again, I sort of always have to have cautions and disclaimers around these things because, of course, we're always playing catch up. So I wouldn't want anyone to think if it's not on the investor alert list, therefore it's safe. And we keep talking about be sceptical, be cynical. The old, if it sounds too good to be true, no doubt it is. The other really big piece of work that we've done though, Kirsten, is with the banks. So there's been a lot of talk about what should the role of the banks be in relation to scams? Should the banks automatically have to recompense people that lose money through scams? And we've done two really big pieces of work in relation to banks and their anti-scams practices. One in the middle of, one in 2023, I think it was, and another one last year. And look, there's so much information in both of those reports, but we did find that the anti-scam practices were less mature than we had expected. And so we've been doing a lot of work. So we've got our disruption work, but we've also been working with financial institutions to say, look, here's some best practices, here's the kind of things that we would expect from you. And then again, of course, we have enforcement work. So the biggest case that we have recently taken in relation to scams was against HSBC Australia. And again, some of the viewers might be aware of a really significant global scam that involved HSBC customers. Very sophisticated scam where the scammers were able to sort of infiltrate genuine text message chains between the real HSBC and their customer. Somehow scammers could get in the middle of that, impersonate HSBC, and people lost very significant sums of money. Our concern in that case was that, and there's all allegations, it's before the court being defended, so I just need to make that clear. But our allegation in that case is that HSBC was well on notice, had been for quite some time, about what was happening and about how its brand was being used and that people were losing very significant sums of money. And our allegation is that they didn't do enough to protect and to stop what was happening to their customers. And so it's different, obviously, to the conversation we were having earlier about cyber resilience and cyber security. But you can see, it's related. And what we're really saying in the HSBC case is you were on notice, people were losing money, very real victims, and your response was insufficient, both in terms of acting to introduce systems that would prevent the scams from happening, but as importantly, in terms of the response to its customers who had been impacted. And there were some really, shocking stories of people just not being able to speak to anyone. And not only in that case, again, all allegations, were there significant delays in dealing with customers, but customers' bank accounts were frozen while HSBC investigated what was going on. So these customers had not only lost all this money, they were no longer able to use their bank accounts for what we alleged to be protected periods of time. So look, that is a significant case, and that will provide some guidance either way, whether we win or whether we lose, on just what are the obligations on a large financial institution when it's faced with that kind of activity.
It's interesting, isn't it? Listening to your description of the activities that you've just been through. On the one hand, it sounds like efforts to inform consumers as much as possible, to be sceptical and to not be sucked in by crime of this kind. And then with the HSBC enforcement action is allegations that a financial institution hasn't done enough to protect customers who've been the victim. In the middle, though, of course, are the criminals themselves.
Yes.
Is that the role of the police or some different agency?
Well, and in this particular case, I'm sitting here now, I don't know where those criminals are, which jurisdiction they're in. I don't know if any regulator around the world knows where they are. I mean, there is, I wouldn't want to give the impression that there's nothing that can be done against, in relation to criminals, and ASIC does from time to time, with the assistance of the AFP, do significant criminal, I mean, again, it comes back to that use of the word scam, and we do significant investigations into economic crime and fraud with the assistance of the AFP, and sometimes they involve people that are located overseas, and then other agencies, of course, around the globe take their own actions in relation to cybercrime as well. But I think, you know, our job here in Australia is looking at these big financial institutions who have the privilege of holding these financial services licence, and in our view, their customers have a quite legitimate, reasonable expectation that when on notice that customers are being the subject to particular crimes, scams, fraud, that those entities will do everything reasonably necessary to protect, detect and respond to those things. So we'll see.
Yep. That makes sense. You maybe have already covered this, but the scams prevention framework and ASIC working with other regulators to achieve those protections. Could you talk about that a little bit?
I can talk about that because it's a really significant new reform, and it only passed through the Parliament a month or so ago. So, and just again, for people that are unfamiliar with it, one of the things the government introduced, so it helped create the National Anti-Scam Centre, but was very concerned to introduce a new legislative framework to help consumers navigate scams, particularly people that have become victim of scams. And as I said earlier, there's been lots of discussion about, you know, where should liability sit for reimbursement or compensation to those people. So the new scams prevention framework will initially cover the banks, the telcos and digital platforms. And the intention is for there to be mandatory codes, scams codes, created in relation to each of those particular sectors, with overarching high-level principles that will sit in the legislation that will be administered by the ACCC. So it's a unique kind of framework in some ways, but the legislation itself has been passed that introduce the framework, and the ACCC is the key regulator, and we and the ACMA have been working very closely with the ACCC in relation to this. There is still work to be done now to create 3 specific codes: telcos, digital platforms and banks. And the idea of the codes will be that they impose a whole lot of very practical and mandatory obligations on participants in each of those sectors to protect, prevent, disrupt and then respond appropriately where people are victims of scams. So there's work to be done, but it has the potential to really be a game changer for people's experience.
And in the development of those codes, sounds like to the extent ASIC's involved, it would be most likely to be involved in the code that applies to the banks. Is that right?
Indeed. Yeah, that's right. So we are expecting to be the regulator that is responsible for dealing with the banks, and you know, in our view, that makes a lot of sense because we're dealing with the banks day in and day out. The other thing I should say too is that these are just the first 3 sectors, and the government has indicated. I know it's been said publicly by the minister that superannuation is another area that may ultimately be designated, and there may be others across the economy as well. So look, it's a very interesting. You know, we really welcome this, and we will work very closely with the ACCC in terms of administering it, enforcing it in this transition period.
Yeah, this structure sounds a little bit similar to the proposed digital platforms regulatory structure.
A little, I think. Well, and of course, the digital platforms will be subject to their own code in relation to scams that the ACCC will administer. So the ACMA, the Communications and Media Authority, will oversee the telcos' obligations, will oversee the banks' obligations, and the ACCC will oversee the digital platform obligations. And the banks, and perhaps to a slightly lesser degree, the telcos have been, very keen to make sure that the digital platforms are brought into this conversation. Again, the digital platforms are predominantly located overseas and not always immediately receptive to the efforts of Australian regulators to bring the force of law. And I think the Information Commissioner, had a long-running argument with Facebook in the federal court where Facebook was just saying, you don't have any jurisdiction. So nobody's pretending this will be easy, but so many of the scams that we see originate on a digital platform. Someone's scrolling through TikTok or Instagram, whatever it may be, and up pops the opportunity that says, do you want better returns on your super? Come and click on this link, and then off you go into this world that looks so completely real and persuasive, and then that's where the scam starts.
It does sound like, picking up on one of your earlier comments, scams probably isn't really the right terminology, is it? It sort of has connotations from a consumer's perspective. Oh, that was really stupid of me, I shouldn't.
Yeah.
But the terminology you've used, cybercrime or economic crime, seems to be more appropriate, at least to describe the sort of conduct that your efforts are addressed at.
Yeah, and even I was sort of regretting my use of language a moment ago, talking about people being sucked into a scam. It's not the right language to use because it almost has that connotation that people have been somehow foolish. And one of the things we're trying to really get away from is any sense for people that they've done anything wrong or they should have been more diligent. That's just not the message. In fact, the complete opposite. What we are all trying to do across all the regulators is really getting people to talk about scams, talk about when they've been scammed, because one of the most powerful ways of educating people and letting them know how difficult these things are to detect is by hearing from stories of people that have unfortunately been the victim of a scam. So, and it is, Kirsten, it is global organised crime. The stories that we hear are extraordinary. There are entire scams compounds in some countries which are just like an entire little town or compound which is just full of people, sometimes indentured slave labour, who are tasked with contacting Australians, contacting French, contacting whoever, and tricking them out of money using very, very sophisticated techniques to do so. So I think the more that we start talking about it as economic crime, economic fraud, probably the better. I think it really is clear what we're talking about.
Yeah, and as you say, somehow getting information out there to people who might be the victims of the sorts of things that are happening. In that respect, are the participants of the scams prevention framework, the telcos, the banks and the like, are they part of that in terms of conveying information to
very much
the people that they connect with about what they're seeing?
Yeah, very much so. I mean, I can probably talk with the most authority about the banks because that's who we've done, so much work with. But some of the banks in particular are being extraordinarily proactive about educating their customers. And I think anyone who does online banking now, certainly my bank, there is very frequent information on the app or on the web page about scams and protect yourself. And they've introduced things like payee identification, so some of the banks. And for example, if you think about the code, the mandatory code under the scams prevention framework, and I don't have any inside information here, but as an example, one of the obligations in the scams prevention framework might be that banks have to use the pay identification technology. So as the way that that works is you put in a new account number and they check that the account number matches the name, and so that can catch people out, obviously. And so that seems to be, the evidence is that can be an effective way to stop scams. So that might be an obligation, for example, that's included under the new framework, that all financial institutions have to introduce that.
Okay. Well, that's a huge job in and of itself. But maybe we move to our next broad topic area, digital asset regulation and enforcement. Even what is a digital asset is something that's a bit mysterious to some. Could you speak to ASIC's approach to the crypto market regulatory framework and digital asset related financial services licenses, please?
Yeah, no, I'm happy to talk about crypto. And look, there's a lot of talk about crypto at the moment and whether it should be regulated, and if it is regulated, how should that be regulated? And I think so the most important and fundamental point from our perspective about crypto, which is often lost, I think, in these various discussions, is that under our existing framework of financial regulation, there is already, a very broad and technology neutral concept of financial products and services, and ASIC has jurisdiction in relation to financial products and services. Now, I should say what is a financial product or a financial service is far more complicated than I ever would have imagined before I came to ASIC, and there's entire cases on, is something a financial product or is it not? But I think the important kind of preliminary point to make is that a whole lot of the things that are out there being called digital assets or crypto assets, in our view, are financial products. They already fall within the law and therefore they're regulated. And what that means is that firstly, you need a licence in order to sell them, and that secondly, all the obligations of a licensee fall upon you. So that's kind of the first issue. And we think that a number of crypto asset businesses already need a licence. So we think it's a financial service or product and it needs a licence. We're particularly interested, and again this will come as no surprise, in services or products that are offered to retail investors. So, and we have said, and again Joe Longo, our chair, has been talking about crypto over the last few years a lot, and he is sort of unapologetic in saying, crypto in particular is an inherently risky investment. So you just, yes, maybe you can make enormous gains, but you can also make very significant losses, and that's why very much why we're here. So inherently risky, volatile and complex, and it's a highly speculative activity. However, they're not illegal, and we are genuinely neutral in relation to these assets. What we want to make sure is that we have the appropriate legal protections in place for consumers and for investors. We've taken a range of enforcement cases already in this area, and we've taken cases where there's been an offer made to a retail investor, like a mum and dad investor, and we think that the product or services that has been offered is a financial product, and that the appropriate consumer safeguards should therefore apply. I think it's fair to say we've had mixed success in the cases that we've taken, but that's kind of fine from our perspective because it's really helping to clarify the law in what is the law is helping us to clarify, the courts are helping us to clarify what is or what is not a financial product. So some of the cases that we've taken, one matter that we took involved the Coin wallet. Now Coin spelled Q-O-I-N, the Coin wallet. That was a non-cash payment facility that used a crypto asset token that they called Coin, and the court determined that that was a financial product and therefore that a licence was required. In another matter, the matter of Finder, the court at first instance dismissed our proceedings. So we were alleging unlicensed financial services, and that was in relation to a crypto asset related product called Find to Earn. So in that case, the court determined that it was not a financial product, and we've appealed that. To the full court, so that's still subject to decision. We've taken action against Binance Australia, which is a crypto company alleging that Binance sold high-risk derivative products to consumers, and so we're concerned about the impact on those consumers. And then in another case that we took against the Australian operator of the Kraken crypto exchange, the court found that the particular product being offered was a credit facility and therefore that it was a financial product, and the court imposed an $8 million penalty in relation to that. So there has been some concern from the crypto industry that has been voiced recently that says ASIC shouldn't be taking enforcement action where these things are unclear. In a sense, I think the allegation is that we are, what's the right word, creating crypto regulation ahead of a government policy position. So look, we're mindful of that clearly, and in fact we are right at the moment consulting on updating our regulatory guidance on crypto-related issues and where we think the various lines are. So I think that a lot of these court cases have fed into those revisions, and industries contributing to that as well. And the government has committed to designing crypto-related legislation. I think it's very unlikely that we're going to see that clearly in the term of the current parliament. But both sides of politics, I think, recognise it's an area that needs some clarity in regulation, and indeed that's what many in the industry are calling for.
And do you think, sort of regardless of whether crypto products, if that's the right terminology, are financial products under the current law or not, do you think specific regulation is necessary, or to the extent they do fall within the current financial product laws, those laws are sufficient and work properly given the particular features of the crypto product?
Look, I don't have a strong view on that. I think it's one of the things Treasury in the consultation paper are trying to explore. What I do think, though, is that we need clarity around that, both as a regulator and as industry. So if there's going to be a new suite of laws that relate to crypto assets or digital assets particularly, we have to work out, well, for those products that, as you say, already fit within the definition of a financial product or a financial service, how is that going to interplay? And I think it's probably important for all of us to have real clarity around that.
Yeah, for sure. It's probably that issue that arises in all regulatory regimes. If there's an existing regime and there's a new technology for which a specific regime is being formulated, you want them to work together properly and not impose slightly different obligations on those that are.
I think that one of the real challenges I think about crypto regulation is that the products are all so different. So it's not like you have cash, or you have a particular payment facility like a credit card or something that we're all used to. The products are designed differently. They're by their definition, they are innovative. They are trying to increase competition, which of course, we welcome increased competition to the traditional products. And so what it means is, I think it just makes the design of regulation difficult, because almost every product needs to be assessed on its particular set of facts and how it is particularly designed. So I think, I'm glad I'm not a legislative drafter, because I think that is going to be the challenge, and I think we just have to make sure at ASIC that we keep feeding into the policy discussions and the drafters, the kinds of examples that we are seeing, to make sure that whatever we end up with will properly deal with some of those challenges, to take the guesswork out of the issue.
And probably identifying what are the specific harms that the regulation is needs to be
Are addressing. Yeah, I agree.
Well, our final topic for today's discussion, of course, is AI, because you can't have a discussion about anything without referring to AI, automation, regulation, and risk management. AI and big data, people would say, and this is probably right, are reshaping our economy and promise productivity and innovation benefits, I understand. How is ASIC approaching AI and the regulation of AI, or in your remit?
Yeah, so we have a real interest in AI, both in terms of how it is used in our regulated community, and secondly, whether or not internally there are things that we can be doing using AI to increase our effectiveness and our productivity. I suppose, again, just stepping back a few high-level observations about AI. So very similar to the conversation we were just having about crypto, the current laws apply to AI. So it's not that AI is currently unregulated, and so if AI is used in relation to a financial product or service, and just thinking about it, for example, if AI is used to generate particular individual advertising to particular consumers, and if those promotions or that marketing is misleading or deceptive, then the laws apply. We've got those laws. In the same way, if AI is used to engage in conduct that is unconscionable or has unconscionable outcomes for individual consumers, again, we've got laws to do that. And we have at ASIC taken some cases already using not necessarily AI particularly, but certainly automated or advanced decision-making and algorithms. So in some of the insurance pricing cases that we've taken, we have alleged that the use of algorithms behind the scenes to artificially inflate prices from which a discount is then deducted. We've said we've alleged that that's misleading. That's another case that's in the courts at the moment and being defended. So there is laws that already apply. I think the second thing to make about regulation of AI, and I think you said it in your, or implied it in your opening, is that there's a really wide range of government agencies involved. So ASIC's very interested, but we are one of many. In fact, I think it's the Department of Industry that's leading a lot of the government policy development and thinking about AI. And in that context, the current discussion is about mandating guardrails for use in relation to AI in high risk settings. And so we are very much supportive of that and will contribute in any way that we can. And I think the third sort of overarching point to make about AI is that it could have real benefits in the financial sector. And so we certainly don't want to be overly conservative or overly reactive. We very much support its safe and responsible adoption. In terms of what we're doing, we've spent a lot of time over the last 12 months or so engaging quite deeply with our regulated community about how they're using AI. So really looking very closely at a number of those entities. And it was interesting because it was really variable. So I think a lot of them would say, oh yeah, we sort of adopt AI, but when you get down to it and find what you're actually doing with it, perhaps wasn't quite as mature or advanced as we were expecting. But just a few findings of that review. We did find that the use has rapidly increased just over the last sort of 12 months or so. So it's sort of gone from a low base, but it now is very much on the increase. But having said that, most of the licensees are being quite cautious about it. So I think we're all, feeling both from the regulator side and from industry side, being a little cautious, and that the real focus of its use has been on augmenting and supporting human decision making and improving efficiencies, which I think is something we can all relate to. It was interesting and of slight concern to us that nearly half of the licensees that we serviced didn't have policies in place that considered fairness to consumers or bias in decision making. And again, that's really where our one of our real concerns is, just to make sure that there is not unfair or unlawful, discrimination in the use of AI. And I think, again, one of the other things Joe has talked about from time to time in relation to AI is, you can't outsource your responsibility. So you can't say, oh, well, it's not our fault that ad was misleading, AI did it. It's not our fault there was market manipulation there, that's just our algorithms playing together. So that's...
that Canadian airline case.
Yes.
Where the chatbot said something along the lines that the customer could get a refund or reschedule their flight or whatever it is, and the Canadian airline, I don't remember which one it was, said, well, that wasn't right, but that wasn't us.
It wasn't us.
AI.
It wasn't us.
Of course it was you.
And I think that, so that's very much, part of our message is that, if you're going to use AI, well, all power to you, but you own it, like whatever the AI does under your watch, then, you will ultimately be liable and responsible for that. So we're going to very much continue to monitor the use of AI across all of our entities.
And what about ASIC itself? We heard from the ACCC chair at the Enforcement Priorities speech the other day. There was a question asked about what the ACCC itself is doing with AI. So I'm going to ask the same question of you. What's ASIC doing internally with AI? Are you using it for, I don't know, document review, or what are you doing with it, if anything?
Well, we're exploring the use of it across our regulatory remit, and I think it's fair to say our people are very interested in it and excited about the opportunities. We're certainly using it in terms of assessing the high volume of reports of misconduct that we get in and reportable situations, and we are trying to train it, if that's the right word, to help us more. I mean, this is sort of it's the ultimate, prize or goal of a regulator. We're trying to use it so we can more easily and more rapidly detect and disrupt financial harm. So, we see there's real opportunities there. We're currently using machine learning that's being developed by our data analytics team, and we've got a lot of data analysts in at ASIC, and we get a lot of data. That's another thing that's quite different from the ACCC, because there's mandatory provision of data from a huge range of entities. And again, one of the real challenges, I think, for regulators is, we've got all this data. It should be a really rich source of information, and, where is misconduct and harm arising. So we're very much focused on that. And look, we really are going to, I think the next few years, Kirsten, will just see us increasingly working out and using AI tools to really enable us to interrogate that data in a very granular way.
All right. Well, we'll all see how it evolves.
Indeed. You have to ask me back again to see how it's gone.
We'll definitely take you up on that. We've pretty much used up our hour. We've only got a minute or so left. So I don't have any more questions for the moment, but, this is a conversation that could keep going for
Yes, indeed,
for ages.
It could.
Sarah, thank you so much for sharing such valuable insights with us today. It's been a fascinating discussion which has skated over quite a lot of topics: cyber risks, scams, digital consumer protection and AI regulation, all of which we could have delved much deeper into.
A lot deeper, yes. You could have a topic on each of them.
Topic on each of them. Each of which, of course, is increasingly critical for businesses and what businesses are doing, or harms to consumers, obviously directly relevant to your priorities. As today's discussions made clear, ASIC's taking an active role in digital financial regulation and doing a huge amount to strengthen enforcement efforts on cyber resilience, scams and AI risks. Obviously for our audience, there's a whole lot of messages that Sarah has given about compliance expectations, governing expectations, and generally understanding the evolving regulatory landscape. Before we wrap up, I'd like to thank all of you for joining us for this session of Digital Economy Live. And again, thank you, Sarah, so much for having me. Such an interesting discussion. Our next webinar in this series is going to focus on cyber megatrends from the US.
So maybe I should
watch that one, Sarah. And looking at what might be over the horizon for Australian businesses and executives and regulators. We're going to be joined by Luke Dembosky, who's the former US Deputy Assistant Attorney General for National Security, and he's now co-chair Global Data Strategy and Security at Debevoise and Plimpton, which is a US law firm. He's going to be in conversation with our Clayton Utz cyber expert partner, Brenton Steenkamp. That session is going to be held on the 31st of March and promises to be another insightful discussion, and we do hope you can all join us. In the meantime, if today's discussion has raised any questions or you'd like to continue the conversation, which I'm sure everybody will, please feel free to reach out. And thank you again, Sarah, for such an interesting discussion. And thank you all for attending. We look forward to seeing you next time.